From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The House passes a bill from Liz Cheney to reform the counting of electoral votes and help prevent a repeat of the January 6th riot. What will this legislation do, and why has it taken Congress so long to get here? Welcome, I'm Kyle Peterson with the Wall Street Journal. We're joined today by my colleagues, columnist Kim Strassel and editorial board member Monet Ukwe-Barua. Welcome to you both. The Presidential Election Reform Act is the House version of this bill. It's 38 pages long and was introduced last week by Liz Cheney and Democrat Zoe Lofgren, and it substantially updates the 1887 Electoral Count Act that currently governs the January 6th session of Congress. Let's listen to a clip from Liz Cheney on the House floor explaining pieces of what this bill would do.
Our bill reaffirms what the Constitution and existing law make plain. The Vice President has no authority or discretion to reject official state electoral slates. It also makes clear that if members of Congress have any right to object to electoral slates, those grounds are limited to the explicit constitutional requirements for candidate and elector eligibility in the 12th Amendment's explicit requirements for elector balloting.
So this bill has now passed the House with lightning speed last week. The vote was 229 to 203, with 9 Republicans voting yes. And there's a Senate companion bill that is a little different in some respects. Maybe the way to go is just to break down the proposals one by one. And to start with where Liz Cheney started in that clip, the House bill says the role of the presiding officer is ministerial on January 6th. And that means, Kim, this is clearly responding to President Trump's argument after the 2020 election that Vice President Mike Pence, as the presiding officer of the January 6th session, could throw out electors or maybe call the whole thing into recess for states to make some investigations or whatever he wanted them to do.
Correct. And that obviously was an enormous catalyst or part of the reason why we had the January 6th riot, in that Donald Trump had been amping up the pressure on Pence for weeks to act. A lot of the people that were marching down and attempted to get in were angry over Pence's refusal to do that. As we have written a number of times, we feel he saved the day by somewhat bravely bucking that pressure and acting in a ministerial fashion. Now, this particular legislation would clarify that, make clear that the vice president really only has one role, which is to preside over an act that is already laid out, ministerial, obviously. Now, one thing just to point out, there is a little bit of lack of clarity in the 12th Amendment about the actual role here, and that can't be fixed by a statute like this. But it would nonetheless, I think, be very important to simply have Congress lay out its own version of the explicit procedure and the guardrails, including the role of the vice president, to try to tamp down on that ambiguity going forward, at least or until at some point, if it were to happen, we had more court guidance on that 12th Amendment provision.
I think that's a good point on the 12th Amendment, because that was, if you read the John Eastman memos that were floating around in Trump world prior to the January 6th session, that's a lot of what it was about. And the key sentence of the 12th Amendment is that the vice president shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. And so the argument of Trump world or John Eastman was that means the vice president is the one who is doing the counting of the votes and can choose which ones to count and which ones not to count. Or at the very least, he's in charge of this joint session. The opposite argument was, look at the language of the 12th Amendment. It says the votes shall then be counted. That's in passive voice. That does not give the vice president, as the presiding officer, the authority to choose what to count and what not to count. But Monet, to the point that Kim was making, I agree that even if we can't get rid of that lack of clarity in the 12th Amendment by passing a law, it would be helpful to the next Mike Pence, who's the next person sitting in that chair, to have it say in statute, to have it say explicitly in Congress's own laying out of its procedures for the January 6th session, that the presiding officer officer's role is basically to preside and not to make any substantive decisions on his own.
Yeah, that's right. I think it gets to the conversation that we have again and again about Congress's responsibility to create the law and the trend in recent years of them deferring that responsibility to judges. And what we have in these Electoral Count Act reform bills is basically Congress stepping up and saying, we are going to refine the definition of this old statute, which has been problematic, instead of it leaving it in the hands of a judge to determine whether the vice president has the responsibility to actually intervene in the count. We are going to say we are interpreting the vision of the founders, who almost certainly did not intend sort of for the vice president to be able to intervene in a political process of this kind. And we're going to put sort of very definitive guardrails on their ability to potentially choose to intervene. I do agree with Kim that ultimately they can't change sort of the constitutionally allotted vice presidential role. And so theoretically, that provision could be subject to a lawsuit. But it seems as if, even though it hasn't been litigated in the past, the prevailing sort of judicial reasoning has been that the vice president can't have this authority. And it's very politically helpful for Congress to come in and say that they agree with that prevailing sort of legal theory.
Another piece of this that I think is important is giving some certainty to which slate of electors coming from a state is treated as conclusive. And some of this goes back to, just to redo some of the history, we're talking about the 1887 Electoral Count Act, and that was passed after the contested 1876 election. And one of the problems there was that you had competing slates of electors. So the governor of Oregon certified one slate of electors. The Secretary of State of Oregon certified a different slate of electors. So those both get passed on to Washington, D.C. and ultimately to Congress. And Congress is faced with this choice of what do we do in this situation where we have competing electors from one state. And the way that the House bill and also the Senate bill, though the language is a little bit different, would deal with that is to say, if we have a slate of electors that is signed or has been submitted by the governor of that state, we are going to treat that as conclusive. And so if there is a rogue official in the Secretary of State's office or something like that, they can sign whatever they want. They can send it into Washington, but it's not going to be treated as if it is real. And Kim, I think that is an important clarification and not something really responsive to what happened in 2020, but certainly you can imagine a situation where there's a disputed outcome in a state and you have, in some states the Secretary of State is appointed, in some states it's elected. So you may have a state where there's a Republican governor and a Democratic Secretary of State or vice versa. And so I think it would be a great improvement to have Congress putting into law, here's what we're going to take. If we get electors sent in by a governor, we're going to treat them as the real ones.
If there's one thing we learned throughout this whole process is never underestimate the way that creative election officials or people that are on the losing side of an election may come up with thoughts or schemes of how they can try to affect a different result. So you're right, Kyle, even though this was not something that was prominent, the heavy discussions about slates of electors and the efforts on the ground in some places to try to gin up some alternate states of electors have certainly made the people who were writing these bills in both the House and the Senate cognizant of the risk of that happening in the future. The other part of this, though, that I do think is very, very important is that you also don't want a situation in which there are some legitimate questions about the outcome of the votes and the elections, and yet this rush at the state level to move ahead. And so this also does give participants in elections the right to go to the federal courts and litigate to a certain extent certain questions about this. Or, for instance, as you said, if a rogue governor refused to actually certify the real winner, at least as that defined by the state's laws governing elections in the state legislature, someone could appeal to a federal court, and that court would then have the power to direct another official to be the one that submitted the official slate. And this particular provision also pushes back the date at which electors have to vote now to December 23rd, which is specifically to allow more time for those kind of challenges to play out. So it provides both a forum for having any disputes settled, but also great clarity about who is meant to be submitting the final slate of electors.
And then we get to Congress's role in this. And under the current Electoral Count Act, here's how it works. The presiding officer, the tellers, as they're called, they read out the electors state by state, and Congress can object to them. And what happens right now is an objection requires only one member of the House and one member of the Senate to have signed it. And then both chambers are required to break for debate to hear the objection. And the objections don't need to be specific. They can be in any vague language. And so that's why we've seen objections about Russian interference, allegedly, in the 2016 election. We saw objections about Ohio voting machines in 2004. We saw objections about Florida in 2000. But that isn't really supposed to be Congress's role to second guess, the counting, the disputes, electoral disputes that happen at the local and state level. And so the first thing that this Cheney bill would do is it would raise the threshold for objections. In order to be debated, an objection would need 1/3 support from the House and 1/3 support from the Senate. And that differs a little bit from the Senate bill, which doesn't go quite as high. That would be 1/5 support in the House and 1/5 support in the Senate. And Monet, I guess this is not the hill I would die on in terms of the exact fraction of what you would need, but it certainly seems like it's an improvement to me to require some consensus of a significant chunk of Congress that there's something wrong before they're going to start actually debating whether or not to throw out these electors. Because if the threshold is currently one member of the House and one member of the Senate, you can probably find one member on either side of Congress to agree with just about anything.
Right. I do think that the difference between the House and Senate bills, whether they require 1/3 or 1/5 of the body to object, is not super material. It seems to be in the right neighborhood in the sense that you want it to be able to be done by a single party. If there were theoretically some real malfeasance and you wanted to have sort of Congress as a backstop on the sort of certification of fraudulent electors, you'd want to have a threshold that wasn't so high that theoretically the party in power would be able to completely steamroll the minority. Especially in this day and age, you're never going to get representation below 1/5 or 1/3 in either House of Congress. And so it still leaves open that avenue for the extraordinary cases. But generally, I agree with you that the threshold certainly is way too low now. Obviously, the incentives for everyone in Congress are to basically just grab the limelight by mounting some kind of frivolous objection to electors when the opposite party has won the election. This has become very famous in the past election cycle because of the events of January 6th, but I think it's important to point out that this has been a bipartisan phenomenon going back years, that the losing party generally has lots of representatives challenging electors and basically taking center stage on the floor to be able to speechify about whatever their sort of trumped up concerns might be. So yeah, I think we're going to see some consensus between the House and Senate about what the threshold should be, but everyone should be in favor of lifting it and making it much harder to have these frivolous objections.